Hi everyone. I know that there are only several days before Christmas, but are you really worried about Christmas or because finals will come before Christmas? Today I'll be reading the part 3 of the Bill of Rights, and if you're not yet already subscribed to our channel, go ahead and hit that subscribe button and let's study together. Thanks.
Exclusionary Rule. Any evidence obtained in violation of the Constitution shall be inadmissible for any purpose in any proceeding. However, in the absence of governmental interference, the protection against unreasonable search and seizure cannot be extended to acts committed by private individuals. That is People versus Marty. This rule is commonly known as the fruit of the poisonous tree. Question: can the exclusionary rule be applied as against private individuals who violate the right of privacy? Yes. Although generally, the Bill of Rights can only be invoked against violation of the government, the court has recognized an instance where it may also be applied as against a private individual, like letters of a husband's paramour kept inside the husband's drawer, presented by the wife in the proceeding for legal separation is not admissible in evidence. The reason is that marriage does not divest one of his or her right to privacy of communication. Veto versus CA. Freedom of speech and expression. No law shall be passed abridging the freedom of speech, of expression, or of the press, or the right of the people peaceably to assemble and petition the government for redress of grievances. That is Article 3, Section 4 of the 1987 Constitution. The rationale behind this is people are kept from any undue interference from the government in their thoughts and words. It flows from the philosophy that the authorities do not necessarily know what is best for the people. And these are the scope of protected freedom of expression under the Constitution. 1. Freedom of speech. 2. Freedom of the press. 3. Right of assembly and to petition the government for redress of grievances. 4. Right to form associations or societies not contrary to law. 5. Freedom of religion. And 6. Right to access to information in matters of public concern. Protected speech includes every form of expression, whether oral, written, tape, or recorded. It includes motion pictures as well as what is known as symbolic speech, such as the wearing of an armband as a symbol of protest. Peaceful picketing has also been included within the meaning of speech. Speech is not limited to vocal communication. Conduct is treated as a form of speech, sometimes referred to as symbolic speech, such that when speech and non-speech elements are combined in the same course of conduct, the communicative element of the conduct may be sufficient to bring into play the right to freedom of expression. The form of expression is just as important as the information conveyed, that it forms part of the expression. Diocese of Bacolod versus Commission on Elections. No, freedom to express one's sentiments and belief does not grant 1. The license to nullify the honor and integrity of another. Any sentiment must be expressed within the proper form and with proper regard for the right of others. Soriano versus LaGuardia. 4 aspects of freedom of speech and press. Freedom from censorship or prior restraint. 2. Freedom from subsequent punishment to publication. 3. Freedom of access to information regarding matters of public interest. Official papers, reports, and documents, unless held confidential and secret by competent authority in the public interest, are public records. As such, they are open and subject to regulation, to the scrutiny of the inquiring reporter or editor. Information obtained confidentially may be printed without specification of the source, and that source is closed to official inquiry unless the revelation is deemed by the courts or by a House or Committee of the Congress to be vital to the security of the state. 4th, freedom of circulation refers to the unhampered distribution of newspapers and other media among customers and among the general public. It may be interfered with in several ways. The most important of these is censorship. Other ways include requiring a permit or license for the distribution of media and penalizing dissemination of copies made without it, and requiring the payment of a fee or tax imposed either on the publisher or on the distributor with the intent to limit or restrict circulation. These modes of interfering with the freedom to circulate have been constantly stricken down as unreasonable limitations of press freedom. Chavez versus Gonzalez, GR 168338, February 15, 2008. It was asked in the 2014 bar. No, there need not be total suppression. Even restriction of circulation constitutes censorship. Political speech. Political speech is one of the most important expressions protected by the fundamental law and have to be protected at all costs for the sake of democracy. GMA Network versus Comelec. Political speech is motivated by the desire to be heard and understood, to move people to action. It is concerned with the sovereign right to change the contours of power, whether through the election of representatives in a Republican government or the revision of the basic text of the Constitution. We evaluate restrictions on freedom of expression from their effects. We protect both speech and medium because the quality of this freedom in practice will define the quality of deliberation in our democratic society. Diocese of Bacolod versus Comelec. Question. Social Weather Station SWS questions Comelec Resolution 9674 requiring them to disclose the names of commissioners and or payers of election surveys on the ground that it is a curtailment of free speech. Decide. SWS is wrong. The names of those who commission or pay for election surveys, including subscribers of survey firms, must be disclosed pursuant to Section 5.2, letter A of the Fair Election Act. This requirement is a valid regulation in the exercise of police power and affects the constitutional policy of guaranteeing equal access to opportunities for public service. Section 5.2, letter A's requirement of disclosing subscribers neither curtails petitioners' free speech right nor violates the constitutional prescription against the impairment of contracts. Conceitedly, what are involved here are not election propaganda per se. Election surveys on their face do not state or allude to preferred candidates. When published, however, the tendency to shape voter preferences comes into play. In this respect, published election surveys partake of the nature of election propaganda. It is then declarative speech in the context of an electoral campaign properly subject to regulation. Hence, Section 5.2 of the Fair Elections Act regulation of published surveys. It is settled that constitutionally declared principles are compelling state interest. Here, we have established that the regulation of election surveys affects the constitutional policy articulated in Article 2, Section 26 and reiterated and affirmed in Article 9, letter C, Section 4 and Article 13, Section 26 of 1987 Constitution of guaranteeing equal access to opportunities for public service. While it does regulate expressions, that is, petitioners' publication of election surveys, it does not go so far as to suppress desired expression. There is neither prohibition nor censorship specifically aimed at election surveys. The freedom to publish election surveys remains. All resolution number 9674 thus is articulate regulation as regards the manner of publication, that is, that the disclosure of those who commissioned and or paid for, including those subscribed to published election surveys, must be made. Social Weather Station versus Comelec. Question. Comelec Resolution 9615 deviated from the previous Comelec resolutions relative to the airtime limitation on political advertisements. It computes the airtime on an aggregate basis involving all the media of broadcast communications compared to the past, where it was done on a per-station basis. The result of which is the reduction of the allowable minutes within which candidates and political parties would be able to campaign through the air. Did Comelec commit grave abuse of discretion in issuing said resolution? Yes. The assailed rule on aggregate-based airtime limits is unreasonable and arbitrary as it unduly restricts and constrains the ability of candidates and political parties to reach out and communicate with the people. Here, the adverted reason for imposing the aggregate-based airtime limits, leveling the playing field, does not constitute a compelling state interest which would justify such a substantial restriction on the freedom of candidates and political parties to communicate their ideas, philosophies, platforms, and programs of government. And this is especially so in the absence of a clear-cut basis for the imposition of such a prohibitive measure. In this particular instance, what the Comelec has done is analogous to letting a bird fly after one has clipped its wings. It is also particularly unreasonable and whimsical to adopt the aggregate-based time limits on broadcast time when we consider that the Philippines is not only composed of so many islands. There are also a lot of languages and dialects spoken among the citizens across the country. Accordingly, for a national candidate to really reach out as to many of the electorates as possible, then it might also be necessary that he conveys his message through his advertisements in languages and dialects that the people may more readily understand and relate to. To add all of these airtimes in different dialects and would greatly hamper the ability of such candidate to express himself, a form of suppression of his political speech. Comelec itself states that television is arguably the most cost-effective medium of dissemination. Even a slight increase in television exposure can significantly boost a candidate's popularity, name recall, and electability. If that be so, then drastically curtailing the ability of a candidate to effectively reach out to the electorate would unjustifiably curtail his freedom to speak as a means of connecting with the people. Finally, on this matter, it is pertinent to quote that Justice Black wrote in his concurring opinion in the landmark Pentagon Papers case, in the First Amendment, the founding fathers gave the free press the protection it must have to fulfill its essential role in our democracy. The press was to serve the governed, not the governors. The government's power to censor the press was abolished so that the press would remain forever free to censure the government. The press was protected so that it could bear the secrets of government and inform the people. Only a free and unrestrained press can effectively expose deception in government. GMA Network versus Comelec. Question. Members of the faculty of the University of the Philippines College of Law published a statement on the allegations of plagiarism and misrepresentation relative to a certain court's decision. Essentially, the faculty calls for the resignation of Justice Mario Pascual in the face of allegations of plagiarism in his work. Does this act of the faculty members squarely fall under the freedom of speech and expression? The answer is no. The publication of a statement by the faculty of the University of the Philippines College of Law regarding the allegations of plagiarism and misrepresentation in the Supreme Court was totally unnecessary, uncalled for, and a rash act of misplaced vigilance. While most agree that the right to criticize the judiciary is critical to maintaining a free and democratic society, there is also a general consensus that healthy criticism only goes so far. Many types of criticism leveled at the judiciary cross the line to become harmful and irresponsible attacks. These potentially devastating attacks and unjust criticism can threaten the independence of the judiciary. Prior restraint and subsequent punishment refers to the official government restrictions on the press or other forms of expression in advance or actual publication or dissemination. Note, there need not be total suppression. Freedom from prior restraint is largely freedom from government censorship of publications, whatever the form of censorship, and regardless of whether it is wielded by the executive, legislative, or judicial branch of the government. Thus, it precludes governmental acts that required approval of a proposal to publish, licensing, or permits as prerequisites to publication, including the payment of license taxes for the privilege to publish, and even injunctions against publication. Even the closure of the business and printing offices of certain newspapers, resulting in the discontinuation of their printing and publication, are deemed as previous restraint or censorship. Any law or official that requires some form of permission to be had before publication can be made commits an infringement of the constitutional right, and remedy can be had at the courts. Chavez versus Gonzalez, GR 168338, February 15, 2008. Exceptions to the prohibition of prior restraint: 1. Pornography. 2. False or misleading advertisement. 3. Advocacy of imminent lawless action. 4. Danger to national security. Soriano versus LaGuardia. Neer versus Minnesota 283 U.S. 697 adds the following to the enumeration. 1. When a nation is at war, many things that might be said in time of peace are such a hindrance to its effort that their utterance will be endured so long as men fight, and that no court could regard them as protected by any constitutional right. Number 2. The primary requirements of decency may be enforced against obscene publication. And 3. The security of community life may be protected against incitements to acts of violence and the overthrow by force of orderly government. Provisions of the revised Penal Code on libel and the provision of the cybercrime law on cyber libel are constitutional. Libel is not a constitutionally protected speech, and that the government has an obligation to protect private individuals from defamation. Indeed, cyber libel is actually not a new crime, since Article 353 in relation to Article 355 of the Penal Code already punishes it. In fact, Section 4, letter C, number 4, merely affirms that online defamation constitutes similar means for committing libel. Furthermore, the United Nations Human Rights Committee did not actually enjoin the Philippines to decriminalize libel. It simply suggested that defamation laws be crafted with care to ensure that they do not stifle freedom of expression. Free speech is not absolute. It is subject to certain restrictions, as may be necessary and as may be provided by law. Note, in her dissenting and concurring opinion, Chief Justice Maria Lourdes Sereno posits that the ponencia correctly holds that libel is not a constitutional protected conduct. It is also correct in holding that generally penal statutes cannot be invalidated on the ground that they produce a chilling effect, since their very nature they are intended to have an in terrorem effect, or benign chilling effect, to prevent a repetition of the offense and to deter criminality. The chilling effect is therefore equated with and justified by the intended in terrorem effect of penal provisions. Thus, when Congress enacts a penal law affecting free speech and accordingly imposes a penalty that is so discouraging that it effectively creates an invidious chilling effect, thus impeding the exercise of speech and expression altogether, then there is a ground to invalidate the law. In this instance, it will be seen that the penalty provided has gone beyond the in terrorem effect needed to deter crimes and has thus reached the point of encroachment upon a preferred constitutional right. Dicine versus Secretary of Justice. Two kinds of chilling effect. Benign chilling effect may be caused by penal statutes which are intended to have an in terrorem effect to prevent a repetition of the offense and to deter criminality. The chilling effect is equated with and justified by the intended in terrorem effect of penal provision, and this is permissible. Invidious chilling effect may be caused by penal laws affecting free speech and accordingly imposes a penalty that is so discouraging, thus impeding the exercise of speech and expression altogether, and this is not permissible. Question: Nestor posted on Facebook that Juan de la Cruz, a married person, has an illicit affair with Maria. Dexter liked this post and commented, "Yes, this is true. What an immoral thing to do." This post was likewise liked by 23 people. Juan de la Cruz filed a case for online libel against Nestor. Dexter and 23 other people who liked the post, using as basis Section 5 of the Cybercrime Law, which penalizes any person who willfully abets or aids in the commission of any of the offenses enumerated in the said law. Is this provision of the law constitutional? The answer is no. Section 5, with respect to Section 4, letter C, number 4, is unconstitutional. Its vagueness raises apprehension on the part of Internet users because of its obvious chilling effect on the freedom of expression, especially since the crime of aiding or abetting ensnares all the actors in the cyberspace front in a fuzzy way. What is more, as the petitioners point out, formal crimes such as libel are not punishable unless consummated. In the absence of legislation tracing the interaction of netizens and their level of responsibility, such as in the other countries, Section 5 in relation to Section 4, letter C, number 4 on libel, Section 4, letter C, number 3 on unsolicited commercial communications, Section 4, letter C, number 2 on child pornography cannot stand scrutiny. Freedom from subsequent punishment. A limitation on the power of the state from imposing a punishment after publication or dissemination. Without this assurance, the individual would hesitate to speak for fear that he might be held to account for his speech or that he might be provoking the vengeance of the officials he may have criticized. This is lifted from the Reviewer of Natura, page 152. The second basic prohibition of the Free Speech and Press Clause prohibits systems of subsequent punishment which have the effect of unduly curtailing expression. Note, freedom from subsequent punishment is not absolute. It may be properly regulated in the interest of the public. The state may validly impose penal and or administrative sanctions such as in the following. 1. Libel. A public and malicious imputation of a crime, vice or defect, real or imaginary, or any act or omission, status tending to cause dishonor, discredit or contempt of a natural or judicial person, or blacken the memory of one who is dead. Article 353 Revised Penal Code. Number 2, obscenity. In Peter v. Court of Appeals, the Supreme Court declared that the determination of what is obscene is a judicial function. Peter v. CA. Number 3, criticism of official conduct. In New York Times v. Sullivan, 376 U.S. 254, the constitutional guarantee requires a federal rule that prohibits a public official from recovering damages for a defamatory falsehood relating to his official conduct, unless he proves that the statement was made with actual malice. Number 4, rights of students to free speech in school premises, not absolute. The school cannot suspend or expel a student solely on the basis of the articles he has written, except when such article materially disrupts classwork or involves substantial disorder or invasion of rights of others. Miriam College Foundation versus CA. Doctrine of fair comment. General rule. Every discreditable public imputation is false because every man is presumed innocent. Thus, every false imputation is deemed malicious, hence actionable. Exception. When the discreditable imputation is directed against a public person in his public capacity, such is not necessarily actionable. Note, for it to be actionable, it must be shown that either there is a false allegation of fact or comment based on a false supposition. The exception to the exception, if the comment is an expression of opinion based on established facts, it is immaterial whether the opinion happens to be mistaken, as long as it might reasonably be inferred from facts. Borhal versus CA. Freedom of the press. The guarantee of freedom to speak is useless without the ability to communicate and disseminate what is said. And where there is a need to reach a large audience, the need to access the means and media for such dissemination becomes critical. This is where the press and broadcast media come along. In the ultimate analysis, when the press is silenced or otherwise muffled in its undertaking of acting as a sounding board, the people ultimately would be the victim. GMA Network versus Kamalek. Question. A national daily newspaper carried an exclusive report stating that Senator Balbas received a house and lot located at YY Street, Makati, in consideration for his vote to cut cigarette taxes by 50%. The senator sued the newspaper, its reporter, editor, and publisher for libel, claiming the report was completely false and malicious. According to the senator, there is no YY Street in Makati, and the tax cut was only 20%. He claimed 1 million pesos in damages. The defendants denied actual malice, claiming privileged communication and absolute freedom of the press to report on public officials and matters of public concern. If there was any error, the newspaper said it would publish the correction promptly. Are the defendants liable for damages? The answer is no. Since Senator Balbas is a public person and the questioned imputation is directed against him in his public capacity, in this case, actual malice means this statement was made with knowledge that it was false or with reckless disregard of whether it was false or not. Since there is no proof that the report was published with knowledge that it is false or with reckless disregard of whether it was false or not, the defendants are not liable for damages. Borjal versus CA. The Borjal Doctrine is not applicable in a case where the allegations against a public official were false and no effort was exerted to verify the information before publishing his articles. Types of privileged communications. 1. Absolutely privileged. Those which are not actionable even if the actor acted in bad faith. Example, Article 6, Section 11 of the 1987 Constitution, which exempts a member of Congress from liability of any speech or debate in the Congress or in any committee thereof. Number 2, qualifiedly privileged. Defamatory imputations are not actionable unless found to have been made without good intention or justifiable motive. To this genre belong private communications and fair and true report without any comments or remarks. Same case, Borjal versus CA. Question. Wincy Diaz penned several articles in Malaya newspaper regarding alleged bribery incidents in the Supreme Court and characterizing the justices as thieves and a basket of rotten apples. The court en banc required Wincy to explain why no sanction should be imposed on her for indirect contempt of court. Did the order of the court violate freedom of the press? Answer is no. While freedom of speech, of expression, and of the press are at the core of civil liberties and have to be protected at all costs for the sake of democracy, these freedoms are not absolute, for if left unbridled, they have the tendency to be abused and can translate to licenses, which could lead to disorder and anarchy. Erica crossed the line, as hers are baseless, scurrilous attacks which demonstrate nothing but an abuse of press freedom. They leave no redeeming value in furtherance of freedom of the press. They do nothing but damage the integrity of the High Court, undermine the faith and confidence of the people in the judiciary, and threaten the doctrine of judicial independence. Differentiate content-based and content-neutral regulation. Content-neutral regulation merely concerned with the incidents of the speech, or one that merely controls the time, place, or manner and under well-defined standards. No presumption of unconstitutionality here. The test to be used is intermediate approach. In a content-based restraint, the restriction is based on the subject matter of the utterance or speech. The cast of the restriction determines the test by which the challenged act is assailed with. There is presumption of unconstitutionality. Note, the burden of proof to overcome the presumption of unconstitutionality is with the government. The test to be used here is clear and present danger test. Facial challenge and the overbreadth doctrine. This was asked in 2015 bar. A challenge to a statute in court in which the plaintiff alleges that the legislation is always and under all circumstances unconstitutional and therefore void. Facial challenge is allowed to be made to a vague statute and to one which is overbroad because of possible chilling effect upon protected speech. The theory is that when statutes regulate or prescribe speech and no readily apparent construction suggests itself as a vehicle for rehabilitating the statute in a single prosecution, the transcendent value to all society of constitutionally protected expression is deemed to justify allowing attacks on overly broad statutes with no requirements that the person making the attack demonstrate that his own conduct could not be regulated by a statute drawn narrow specificity. Estrada versus Sandiganbayan, GR 148560, November 19, 2001. Facial challenge versus as-applied challenge. Facial challenge is an examination of the entire law, pinpointing its flaws and defects not only on the basis of its actual operation to the parties but also on the assumption or prediction that its very existence may cause others not before the court to refrain from constitutionally protected speech or activities, while as-applied challenge considers only extant facts affecting real litigants. And this is in Southern Hemisphere Engagement Network versus Anti-Terrorism Council. Question: is facial challenge to a penal statute allowed? No. Facial challenges are not allowed in penal statutes. Criminal statutes have general interim effect resulting from their very existence, and if facial challenge is allowed for this reason alone, the state may well be prevented from enacting laws against socially harmful conduct. In the area of criminal law, the law cannot take chances, as in the area of free speech. KMU versus Ermita, GR 17855, October 5, 2010. Note, a litigant cannot thus successfully mount a facial challenge against a criminal statute on either vagueness or overbreadth grounds. The rule established in our jurisdiction is only statutes on free speech, religious freedom, and other fundamental rights may be facially challenged. Overbreadth Doctrine. The overbreadth doctrine decrees that a governmental purpose to control or prevent activities constitutionally subject to state regulations may not be achieved by means which sweep unnecessarily broadly and thereby invade the area of protected freedom. Southern Hemisphere Engagement Network versus Anti-Terrorism Council, TR 178552. Note, the application of the overbreadth doctrine is limited to a facial kind of challenge, and owing to the given rationality of a facial challenge, applicable only to free speech cases. The most distinctive feature of the overbreadth technique is that it marks an exception to some of the usual rules of constitutional litigation. Ordinarily, a particular litigant claims that a statute is unconstitutional as applied to him or her. If the litigant prevails, the courts carve away the unconstitutional aspects of the law by invalidating its improper application on a case-to-case basis. Moreover, challengers to a law are not permitted to raise the right of the third parties and can only assert their own interest. In overbreadth analysis, those rules give way. Challenges are permitted to raise the right of third parties, and the court invalidates the entire statute on its face, not merely as applied for, so that the overbroad law becomes unenforceable until a properly authorized court construes it more narrowly. The factor that motivates court to depart from the normal adjudicatory rule is that concern with the chilling deterrent effect of the overbroad statute on third parties not courageous enough to bring suit. The court assumes that an overbroad law's very existence may cause others not before the court to refrain from constitutionally protected speech or expression. An overbreadth ruling is designed to remove that deterrent effect on the speech of those third parties. Dangerous tendency, balancing of interest and clear and present danger tests. Dangerous tendency test. Question: whether the speech restrained has a rational tendency to create the danger apprehended, be it far or remote. Thus, government restriction would then be allowed. It is not necessary, though, that evil is actually created, for mere tendency towards the evil is enough. Emphasis: nature of the circumstances under which the speech is uttered, though the speech per se may be dangerous. Balancing of interest test. Question: which of the two conflicting interests, not involving national security crimes, demands the greater protection under the particular circumstances presented? A. When particular conduct is regulated in the interest of public order. B. And the regulation results in an indirect, conditional, and partial abridgment of speech. Gonzalez versus Comelec. Now, the real question is, can an offensive and obscene language uttered in a prime-time television broadcast, which was easily accessible to the children, be reasonably curtailed and validly restrained? The answer is yes. In Soriano versus MTRCB, GR 165636, April 19, 2009, the court, applying the balancing of interest doctrine, ruled that the government's interest to protect and promote the interests and welfare of the children adequately buttresses the reasonable curtailment and valid restraint on petitioner's prayer to continue as program host of Ang Dating Daan during the suspension period. Soriano's offensive and obscene language uttered on primetime television broadcast without doubt was easily accessible to the children. His statements could have exposed children to a language that is unacceptable in everyday use. As such, the welfare of children and the state's mandate to protect and care for them as parents' patriarch constitute a substantial and compelling government interest in regulating Soriano's utterances in TV broadcasts. Note, in his dissenting opinion, Justice Carpio cited Action for Children's Television versus FCC, which establishes the safe harbor period to be from 10 in the evening to 6 in the morning, when the number of children in the audience is at a minimum. In effect, between the hours of 10 p.m. and 6 a.m., the broadcasting of material considered indecent is permitted. Between the hours of 6 a.m. and 10 p.m., the broadcast of any indecent material may be sanctioned. Clear and present danger test. The government must also show the type of harm the speech sought to be restrained would bring about, especially the gravity and imminence of the threatened harm. Otherwise, the prior restraint will be invalid. Prior speech, based on its content, cannot be justified by hypothetical fears, but only by showing a substantive and imminent evil that has taken the life of a reality already on ground. As formulated, the question in every case is whether the words used are used in such circumstances and are of such a nature to create a clear and present danger that they will bring about the substantive evils that Congress has a right to prevent. It is a question of proximity and degree. The regulation which restricts the speech content must also serve an important or substantial government interest, which is unrelated to the suppression of free expression. Chavez versus Gonzalez. The question in every case is whether the words used are used in such circumstances and are of such a nature as to create a clear and present danger that they will bring about the substantive evils that Congress has the right to prevent. Schenck versus United States. Note, the test can be applied with regard to the freedom of religion when what is involved is religious speech, as this is often used in cases of freedom of expression. State regulation of different types of mass media. Types of mass media: live media coverage of court proceedings. The propriety of granting or denying permission to the media to broadcast, record, or photograph court proceedings involves weighing the constitutional guarantees of freedom of the press, the right of the public to information, and the right to public trial on the one hand, and on the other hand, the due process rights of the defendant and the inherent and constitutional power of the court to control their proceedings in order to permit the fair and impartial administration of justice. Collaterally, it also raises issue in the nature of media, particularly television, and its role in society and of the impact of new technologies of law. Considering the prejudice it poses to the defendant's right to due process as well as to the fair and orderly administration of justice, and considering further that the freedom of the press and the right of the people to information may be served and satisfied by less distracting, degrading, and prejudicial means, live radio and television coverage of court proceedings shall not be allowed. Video footages of court hearings for news purposes shall be restricted and limited to shots of the courtroom, the judicial officers, the parties, and their counsels taken prior to the commencement of official proceedings. No video shots or photographs shall be permitted during the trial proper. An accused has a right to a public trial, but it is a right that belongs to him more than anyone else, where his life or liberty can be held critically in balance. A public trial aims to ensure that he is fairly dealt with and would not be unjustly condemned, and that his rights are not compromised in secret conclaves of long ago. A public trial is not synonymous with publicized trial. It only implies that the court doors must be open to those who wish to come, sit in the available seats, conduct themselves with proper decorum, and observe the trial process. Secretary of Justice versus Estrada. Question: in 2011, the Supreme Court promulgated a resolution partially granting pro hac vice the request for live broadcast by television and radio of the trial court proceedings of the Maguindanao massacre cases, subject to specific guidelines set forth in said resolution. Accused Andal Ampatuan Jr. filed a motion for reconsideration alleging that the resolution deprives him of his rights to due process, equal protection, presumption of innocence, and to be shielded from degrading psychological punishment. Ampatuan contends that the court should accord more vigilance because the immense publicity and adverse public opinion which live media coverage can produce would affect everyone, including the judge, witnesses, and the families of all concerned parties. The OSG, however, contends that the coverage by live media neither constitutes a barbarous act nor inflicts upon the accused inhuman physical harm or torture that is shocking to the conscience and freedom of the press. Should live broadcast of the trial be disallowed? No. The court is now disallowing live media broadcast of the trial of Maguindanao massacre, but is still allowing the filming of the proceedings for 1. The real-time transmission of specific viewing areas, and 2. Documentation. While the court recognizes the freedom of press and the right to public information, the constitutional rights of the accused provide more than ample justification to take a second look at the view that a camera that broadcasts the proceedings live on television has no place in a criminal trial because of its prejudicial effects on the rights of accused individuals. As we have previously held, the live coverage of judicial proceedings involve an inherent denial of due process. In this case that has achieved notoriety and sensational status, a greater degree of care is required to safeguard the constitutional rights of the accused. To be in the best position to weigh the conflicting testimonies of the witnesses, the judge must not be affected by any outside force or influence. Like any human being, however, a judge is not immune from the pervasive effects of media. In a constitutional sense, public trial is not synonymous with publicized trial. The right to public trial belongs to the accused. The requirement of a public trial is satisfied by the opportunity of the public and press to attend the trial and to report what they have observed. The accused's right to a public trial should not be confused with the freedom of the press and the public's right to know as a justification for allowing the live broadcast of the trial. Commercial speech. Commercial speech is a separate category of speech which is not accorded the same level of protection as that given to other constitutionally guaranteed forms of expression, but is nonetheless entitled to protection. The state cannot rob him of this right without violating the constitutionally guaranteed freedom of expression. Unsolicited advertisements are legitimate forms of expression. Disney versus Secretary of justice. It pertains to communication which no more than proposes a commercial transaction, such as advertisements of goods or of services. To enjoy protection, commercial speech must, number one, not be false or misleading, and number two, should not propose an illegal transaction. Note, however, even truthful and lawful commercial speech may be regulated if 1. Government has a substantial interest to protect, 2. The regulation directly advances that interest, and 3. It is not more than extensive that is necessary to protect that interest. Question. EO 51, Milk Code, was issued by the President Valenton in October 28, 1986 by virtue of the legislative powers granted to the President under the Freedom Constitution. On May 15, 2006, the DOH issued revised implementing rules and regulations RIRR, which was to take effect on July 7, 2006. The Association of Healthcare Workers claimed that the Milk Code only regulates and does not impose unreasonable requirements for advertising and promotion, while RIRR imposes an absolute ban on such activities for breast milk substitutes intended for infants from 0 to 24 months old or beyond, and forbids the use of health and nutritional claims. Were the labeling requirements and advertising regulation under the RIRR valid? Yes. Section 13 on total effects and Section 26 of Rule 7 of the RIRR contains some labeling requirements, specifically A. That there be a statement that there is no substitute to breast milk. B. That there be a statement that powdered infant formula may contain pathogenic microorganisms and must be prepared and used appropriately. Section 16 of the RIRR prohibits all health and nutritional claims for products within the scope of the Milk Code, such as claims of increased emotional and intellectual abilities of the infant and young child. These provisions of the Milk Code expressly forbid information that would imply or create a belief that there is any milk product equivalent to breast milk, or which is humanized or maternalized, as such information would be inconsistent with the superiority of breastfeeding. Thus, the RIRR is a reasonable means of enforcing the Milk Code and deterring circumvention of the protection and promotion of breastfeeding as embodied in the Milk Code. Heckler's veto was given into 2014 bar. Occurs when an acting party's right to freedom of speech is curtailed or restricted by the government in order to prevent a reacting party's behavior. The term Heckler's veto was coined by University of Chicago professor of law Harry Calvin. The Heckler's veto involves situations in which the government attempts to ban protected speech because it might provoke a violent response. In such situations, the mere possibility of a violent reaction to protected speech is simply not a constitutional basis on which to restrict the right to speak. Roe v. Crawford, 514 F. 3rd, 789, January 22, 2008. It may be in the guise of a permit requirement in the holding of rallies, parades, or demonstrations conditioned on the payment of a fee computed on the basis of the cost needed to keep order in view of the expected opposition of persons holding contrary views. Unprotected speech. Unprotected speech or low value expression refers to libellous statements, obscenity or pornography, false or misleading advertisements, insulting or fighting words, those by which their very utterance inflicts injury or tend to incite an immediate breach of peace and expression, endangering nation security. Soriano versus LaGuardia. Limitations on freedom of expression. It should be exercised within the bounds of laws enacted for the promotion of social interests and the protection of other equally important individuals' rights, such as 1. Laws against obscenity, libel, and slander, contrary to public policy. 2. Right to privacy of an individual. 3. Right of state government to be protected from seditious attacks. 4th, legislative immunities. 5, fraudulent matters. 6, advocacy of imminent lawless conducts. 7, fighting words. And 8, guarantee implies only the right to reach a viewing audience, but not the right to compel others to listen, see, or read. Freedom of religion. A profession of faith of an active power that binds and elevates man to his creator. Guarantees contained in Section 5, Article 3 of the 1987 Constitution, Non-Establishment Clause and Free Exercise Clause. Non-establishment and free exercise clauses. Article 3, Section 5 states that no law shall be made respecting an establishment of religion or prohibiting the free exercise thereof. Note, the non-establishment clause means that the state should adopt a position of neutrality when it comes to religious matters. The non-establishment clause bars the state from establishing through laws, rules, and morals. Purpose of non-establishment clause. 1. Protects voluntarism, and 2. Insulation of political process from interfaith dissension. Note, voluntarism as a social value means that the growth of a religious sect as a social force must come from the voluntary support of its members because of the belief that both spiritual and secular society will benefit if religions are allowed to compete on their own intrinsic merit without benefit of official patronage. Accommodation. Accommodations are government policies that take religion specifically into account, not to promote the government's favored forms of religion, but to allow individuals and groups to exercise their religion without hindrance. Their purpose or effect, therefore, is to remove a burden on or facilitate the exercise of a person's or institution's religion. Example of governmental accommodation. 1. In Victoriana versus Elizalde Rope Workers Union, the court upheld the exemption of members of Iglesia Ni Cristo from the coverage of a closed shop agreement between their employer and a union, because it would violate the teaching of their church not to affiliate with labor organization. 2. In Ebralinag versus Division Superintendent of Schools of Cebu, the petitioners who were members of the Jehovah's Witnesses refused to salute the flag, sing the national anthem, and recite the patriotic pledge, for it is their belief that those were acts of worship or religious devotion which they could not conscientiously give to anyone or anything except God. 3. In rate requests of Muslim employees in the different courts in Iligan City, the court recognized that the observance of Ramadan as integral to the Islamic faith and allowed Muslim employees in the judiciary to hold flexible office hours from 7:30 in the morning to 3:30 in the afternoon without any break during the period. The revised Administrative Code of 1987 has declared Monday, Thursday, Good Friday, and Christmas Day as regular holidays. Republic Act number 9177 proclaimed the first day of Shawwal, the 10th month of the Islamic calendar, a national holiday for the observance of Eidul Fitr, the end of Ramadan. RA 9849 declared the 10th day of Shu, or Hijjah, the 12th month of the Islamic calendar, a national holiday for the observance of Eidul Adha, rather Idul Adha. Presidential Decree 1083, otherwise known as the Code of Muslim Personal Laws of the Philippines, expressly allows a Filipino Muslim to have more than one wife and exempts him from the crime of bigamy, punishable under revised penal code. The same code allows Muslim to have divorce. Constitutional provisions which express the non-establishment clause. Article 6, Section 29, no public money or property given to religious sect or minister, religious personnel, except for those assigned to army, penal institution, government orphanage, and the Pulsarium. It has also been held that the aforesaid constitutional provision does not inhibit the use of public property for religious purposes when the religious character of such use is merely incidental to a temporary use which is available indiscriminately to the public in general. Number 2, Article 2, Section 6, separation of church and state is inviolable. Article 9, letter C, Section 2, number 5, no religious sects can be registered as political parties. Constitutionally created exceptions to the non-establishment clause. Article 6, Section 29, prohibition on appropriation of public money or property for the use, benefit, or support of any religion. Number 2, Article 6, Section 28, number 3, exemption from taxation of properties actually directly and exclusively used for religious purposes. Number 3, Article 14, Section 3, number 3, optional religious instruction in public elementary and high school. No religious instruction in public schools, at the option of parents or guardians expressed in writing, be within the regular class hours of instructors designated or approved by religious authorities by the religion to which the children belong and without additional cost to the government. Number 4, Article 14, Section 4, number 2, citizenship requirement of ownership of educational institutions, except those established by religious groups and mission boards. And finally, Article 6, Section 29, number 2, appropriation allowed where ecclesiastic is employed in armed forces, in a penal institution, or in a government-owned orphanage or leprosarium. Exceptions to the non-establishment clauses held by jurisprudence. Government sponsorship of town fiestas. Some purely religious traditions have now been considered as having acquired secular character. Number 2, postage stamps depicting Philippines as the venue of a significant religious event, benefit to the religious sect involved was merely incidental as the promotion of Philippines as a tourist destination as the primary objective. And 3, exemption from zoning requirements to accommodate unique architectural features of religious buildings, that is, Mormon's tall-pointed steeple or temple. The non-establishment clause states that the state cannot 1. Set up a church, 2. Pass laws which aid one, all religious or prefer one over another, force or influence a person to go to or stay away from church against his will, or force him to profess a belief or disbelief in any religion, punish a person for entertaining or professing religious belief or disbelief for church attendance or non-attendance, collect tax in any amount can be levied to support any religious activity or institution, whatever they may adopt to teach or practice religion, and 6, openly or secretly participate in the affairs of any religious organization or group or vice versa. Free Exercise Clause. The Free Exercise Clause affords absolute protection to individual religious convictions. However, the government is able to regulate the times, place, and manner of its exercise. Aspects of freedom and enjoyment of religious profession and worship. Right to believe, which is absolute. The individual is free to believe or disbelieve as he pleases concerning the hereafter. He may indulge his own theories about life and death, worship any god he chooses, or none at all, embrace or reject any religion, acknowledge the divinity of God or any being that appeals to his reverence, recognize or deny the immortality of his soul, in fact, cherish any religious conviction as he or she alone sees fit. However absurd his belief may be to others, even if they be hostile and heretical to the majority, he has full freedom to believe as he pleases. He may not be required to prove his belief. He may not be punished for his inability to do so. Iglesia Ni Cristo versus CA. Number 2, right to act on one's belief, which is subject to regulation. Where the individual externalizes his belief in acts or omission that affects the public, his freedom to do so becomes subject to the authority of the state. As great as this liberty may be, religious freedom, like all the other rights guaranteed in the Constitution, it is limited and subject to the police power of the state and can be enjoyed only with proper regard to rights of others. Benevolent neutrality. Benevolent neutrality is an approach that looks further than the secular purposes of government action and examines the effect of these actions on religious exercise. Benevolent neutrality recognizes the religious nature of the Filipino people and the elevating influence of religion in society. At the same time, it acknowledges that government must pursue its secular goals. In pursuing those goals, however, government might adopt laws or actions of general applicability which inadvertently burden religious exercise. Benevolent neutrality gives room for accommodation of these religious exercises as required by the Free Exercise Clause. It allows these breaches in the wall of separation to uphold religious liberty, which, after all, is the integral purpose of the religious clause. Conscientious Objecture. An individual who has claimed the right to refuse to perform military service on the ground of freedom of thought, conscience, and/or religion. Requisites for one to be considered a conscientious objector. 1. The person is opposed to war in any form. 2. He must show that this opposition is based upon religious training and belief. And 3. And he must show that this objection is sincere. Clay v. United States 403 U.S. 698 June 28, 1971.